I'd like to call to order meeting of the Greenwood Advisory Plan Commission for Monday, May 13th, 2024. First item on the agenda is approval of the minutes from April 22nd. Is there a motion?
I move to approve the minutes.
Motion by Mr. Lexi.
Second.
Second by Mr. Walker. All in favor, please show by raising a hand. All opposed, same sign. Motion passes 9-0. Special requests or continuances.
I'll start off with PC 2024-011 National Pride Car Wash. They have just notified us that they have withdrawn their petition, so they are no longer requesting a continuance. They are requesting a withdrawal. So you can cross them out from the special requests and continuance. And then later on in the agenda, they were the first thing under old business from the floor. You can remove them from that location as well. The other two petitioners should be here to request continuances, and they did not specify a date to staff. So if they choose to do so, they should tonight.
Okay.
2024-012.
Yeah, we'll start with 2024-012. Almona Estates 2 primary plat. Is there someone to speak on this?
Hi, my name is Neil Doradio with Apollo Developers, and I'd like to request a continuance on Elmwood Estates 2 primary plat. We've submitted plans and answered all the comments that we've received. We are just working through the MOU and interlocal agreements between Greenwood and Whiteland in order to finalize the project.
You have a date that you'd like to come back?
May 29th.
That would be 2 weeks and 2 days, actually. The next meeting is on,
It said May 29th.
oh, May 29th. I'm sorry. I thought you said a week from tonight. I misunderstood you. Yeah, well, okay, May 29th.
With, if I may, from staff,
Sure.
we have not yet seen the agreements or MOU. I don't think our legal department has seen them either. I would just ask that enough time was provided for staff and legal to review the agreements.
When would you like to see those? No later than.
I was told we would receive them last week, Friday, I believe, and I have not seen them at this time.
Should we then go to June?
But I don't know when the petitioner plans to have those before staff.
The attorney mentioned he would have them ready by this evening, and I can send them tomorrow morning. Hopefully that's enough time before the next technical review committee. But is that enough time for you to review?
That would put us for a technical review meeting
On the 22nd.
on the 22nd. So that we could possibly give them a different recommendation than the current one that staff has included.
That would give you 1 week.
So that would be cutting it close for Whiteland and the city of Greenwood to do a full review of the agreement. I don't know if that would be enough time.
Do you prefer to
Okay.
see June 10th?
June 10th probably sounds more reasonable at this point then.
Okay.
And just for clarification, from my understanding, it was an agreement that all parties can kind of nod their head and agree that that's the proper framework for moving forward. It wasn't necessarily a signed and notarized document. Is that correct?
I think that we could do well, it'd be up to plan commission, a conditional approval if they are comfortable with the agreement language and maybe have some confirmation from city engineering, planning city legal, and also maybe an email or a note from Carmen with Whiteland saying, hey, everything looks good. I think Plan Commission might feel comfortable enough to approve it conditional upon the agreement, even if the agreement is not fully executed. But I do think we should be in a spot where we have some, I guess, some type of evidence that all parties are comfortable with it.
Well, you have to recall that an interlocal agreement must be approved by the fiscal body, so that would have to go to the common council for approval. So all we would have is, hey, we've all struck terms, but it would have to go before the common council to be approved.
So they could, Plan Commission, not me, could conditionally approve it on common council's blessing. But at this point, staff has been unfavorable because we have seen no such draft of the agreement, so we're not comfortable moving forward.
So June 10th would be the soonest you want us to even think about.
Yes.
And there would be some, I guess some of this is at the petitioner's, I don't know how to say it, petitioner's choice, right? And if they don't get it done, then they'd have to, well, they wouldn't be able to continue again. They'd have to re-advertise for a public hearing on a primary plat. Is a risk they take.
But just to be clear, doing it
Understood.
doesn't require that, correct?
Correct, not this time. They can continue one more time for a.
Gotcha.
This is their second
So they
continuance.
couldn't do it
Okay.
again. Yeah.
Okay.
So is the petitioner comfortable taking that risk on June 10th, or would you rather push it back to June 24th?
We're comfortable with the June 10th.
I'm comfortable if we can get it before us in the near future.
Okay. Is there a motion?
Move to approve continuance to June 10th.
Motion by Mr. King, second by Ms. Stambaugh. Are there any other questions about it before we vote? Seeing none, all in favor, please show by raising a hand. All opposed, same sign. Motion carries 9-0. We will see you on June 10th, sir.
Thank you.
PC 2024-017. Is there someone here to speak on behalf of Lennar Homes?
Hello, good evening. Tony Pagano with Lennar Homes. Our address is 11555 North Meridian Street, Suite 400 in Carmel. And just working with some of the comments still with staff. So we're requesting a continuance, and I would like the June 24th hearing. Just make sure we have time to work through it and give responses back to staff and work through anything if they come up again in hopefully enough time within 6 weeks.
Okay. Mr. Nelson?
Staff would be comfortable with that date. There's nothing, to my knowledge, on that agenda at this time.
Motion to approve the continuance,
To
June 24th to June 24th.
Second.
just want to get that motion.
A second.
Walker.
Motion by Ms. Stambaugh, second by Mr. Walker. Questions by anybody? Not all in favor, please show by raising a hand. All opposed, same sign. Motion carries 9-0. Mr. Pagano, thank you for coming tonight. We'll see you June 24th.
Thank you.
The findings of fact. Do you have any old business? Seeing none. Old business from the floor. First item, PC 2024-011 has been withdrawn. Second item, PC 2024-012 has been continued to June 10th. New business. First item, PC 2024-017. This primary plat has just been continued to June 24th. Next item is PC 2024-02 Wawa Landscape Waiver. This is not a public hearing. On behalf of the petitioner, would you like to introduce yourself and give us your address?
Yes, hello everybody, Nathan Barr, Kennedy North, 500 East 96th Street, Suite 300, Indianapolis, Indiana.
Okay. Mr. Barr, please proceed.
So we are proposing for a landscape variance for foundation paintings along for the Wawa project. Project has two frontages, one along US 31 and then one along Horseville. We are just proposing that the foundation paintings be relocated. We did submit to staff and for those foundation paintings.
They are requesting a waiver of section 10-03-06, minimum width of 10 feet along the full length of the foundation facing a street.
Staff recommendation is approval.
Staff does recommend approval. Staff finds that relocated landscaping achieved the intent and quantity of the landscaping that was supposed to be in the foundation for commercial properties under 25,000 square feet.
Okay, thank you. Are there any questions by the commissioners? Statements? Seeing none, I would accept a motion.
Mr. President, I move that the request of applicant Kimley Horn on behalf of Unicore National Developments Incorporated for a waiver of the requirements of the Unified Development Ordinance, Greenwood Municipal Code, Chapter 10, Article 25, Division 3, Generally Applicable Regulations, Section 10-03-06, Landscaping and Buffering, G, Foundation Plantings, that specifies that commercial properties under 25,000 square feet shall have a minimum 10-foot wide landscaping strip along the full length of a foundation facing the street. To permit relocation of the plantings required to other areas of the site because the physical constraints of the site regarding utility clearances along US 31 and the usable area for sidewalk placement for safe access to the building reduce available foundation planting area be approved, and that the Planning Commission find that applicant has met the criteria set forth by Greenwood Municipal Code, Section 10-04-03K, for the waiver for the reasons set forth in its request for waiver and as presented.
We have a motion by Mr. King. Is there a second? Excuse me. By Mr. Milmore. Questions or comments on the motion? Seeing none, all in favor, please show a sign of a hand raised. All opposed, same sign. Motion carries 9-0. Mr. Barr, good luck with your project.
Thank you.
Next item we have is an order of demolition at 304 East Broadway Street. This is a public hearing. And the enforcement authority is Mr. Kenneth Seal, Building Commissioner for the City of Greenwood. We'll have you open the hearing regarding enforcement action. Mr. Seal, could you state your name and address?
Kenneth Zeal, Building Commissioner, City of Greenwood, 300 South Madison Avenue, Greenwood.
Would you administer the oath?
No, that's-
Oh, Sorry.
Would you please be administered the oath for your testimony?
Do you
Thank
swear on these perjury testimony to the best of your knowledge? Thank you.
And anyone else, I don't know if there's anyone online for this, anyone who's the owner or who has a substantial interest in the property may also testify.
At this time, I have approached the commission. I have some handouts to be entered into the record.
Please.
Okay, so we are here today somewhat as a continuation from enforcement measures from the Department of Code Enforcement, specifically Supervisor John Lau. You'll see Exhibit A is the notice of, order of demolition, notice of hearing in accordance with IC 36, 794. And follow on, we have to provide notice of the hearing anytime we move for demolition of a property. Exhibit B, which we'll reference in just a moment, is some photos of the area. Exhibit C is a receipt of the certified notice. Exhibit D, E, F, and G are notice of served by the Greenwood Department of Code Enforcement over the past couple of months. If you reference page 2 of Exhibit A, towards the bottom, there is a little bit of a timeline I'd like to just touch on. And that is that this enforcement measure from the city of Greenwood goes back to 15 November 2023, where Supervisor John Lau at that time cited two vehicles, household debris scattered throughout the rear yard, and a detached structure that was leaning and in need of repair. Notice of correction was placed at the property on 16 November. On 12 December, I was asked to go by and perform an evaluation of the structure, which I did on that same day. The legal department did send out a notice that would be Exhibit G. On 26 December, John Lau did meet with Mrs. Thornton and agreed to work through the abatement. Although zero progress has been made as of the date of this order, despite the city of Greenwood allowing additional time and referring resources to assist the abatement. Mr. Lau went as far working with Mrs. Thornton to coordinating volunteers with the local church and as well as a local dumpster service, Best Way, to assist in that abatement, which there was an initial agreement there, but again, no contact has been able to be made by the property owners since. The general condition does warrant removal. It does meet the definition of each of the unsafe building definitions provided by the State of Indiana, and the City of Greenwood. And as you can see in Exhibit B, not only the debris scattered about, you'll also notice that while the folks were home at the time, no one would come to the door, so I did post the notice at the property as well, as sent it by certified mail. 3 other photos, specifically one taken from the side yard, can show a significant lean on the structure. Another showing the buckling door and overall family condition. It's my opinion that it's a matter of time until this property comes down by wind or other type of weather events that may affect it is not in good shape. Mr. Lau did serve a total of 3 orders, only one of which though was specific to the structure. And that order is located on Exhibit D. Exhibit G, which I referenced earlier, was the order from our legal department, from Mr. Joseph Saylor, basically indicating that the city was going to move towards possible abatement and possible fines. All of the notes and progress from Mr. Lau's visit are public record, both on city servers and in the City Works software that we utilize, notating each contact with the homeowners. And again, at this point, does not appear, at least on the surface, that anybody is here to represent that address. And if that be the case, does anybody have any questions that I may answer?
I have a question. Repair the deteriorating detached garage or remove from the property is a choice, or is you specifying a choice that you recommend?
All right, yes, so you're referencing Exhibit D?
Yes.
Okay,
What exhibit was that?
D, Exhibit D, yeah. So Exhibit D was an order issued by John Lau. He is the code enforcement supervisor. The code enforcement division works out of Chapter 6 or Article 6 of the Property Maintenance Code. So while he can order something that is blighted or deteriorated or failing, he can order it to be repaired, okay, because it falls under the property maintenance, whereas my department has the authority to order it removed. So I think in this situation, he was essentially giving them a choice to either repair it or remove it, but he wasn't necessarily ordering it to be removed.
Okay, thank you.
So he's basically saying, make it stop leaning, paint it, make the garage door not cave in.
Right, yeah, that's correct. So to make it supported, make it safe, you know, for the purpose of storage of items or personal entry occupancy.
And that was nearly 6 months ago.
But that is correct. That's going back to November, where that conversation began.
Any other questions? Yes, sir, Mr. Miller.
Was the determination made on site, or did somebody actually go in the building and look at it? Or?
Nobody has entered the building, and likely for good cause. When you look in through the window, it is built almost to the brim with materials and just things that have been collected over the years. And there's a possibility that removal of those items or that debris would be catastrophic to the structure. It may be the only thing holding it up at this point.
Maybe some critters in there too.
Yeah.
One other question.
Yes, sir.
Are the 2 cars that are in the, wherever they're located on the property, have they got current license plates?
They do.
Okay.
It appears I can work on my photo taking abilities. I
Well,
was not
that's okay.
necessarily there for,
No,
the vehicles, as that is a property maintenance, code enforcement
Sure.
issue. However, in, Mr. Lott's, notes in the system, he did state that, it was approximately 30 days later, I believe, that the vehicles did get, the tags removed.
I don't even know if this is an okay question to ask, but for Mr. and Mrs. Thornton, do they give reasons as to why they are abiding or proceeding with any of the recommendations from the city? Is there like an ADA issue? Is there a, something, I'm just curious.
Any of my own comments would be pure speculation. However, in speaking with John Lott, who has had conversations with them, it appears to be an aging mother and daughter who live there. That there is not a male in the household or husband. They may or may not be deceased, depending on they're in age. And that is one of the reasons why, especially after December 12th, myself visiting the site, Mr. Lau and I, we met, we had a conversation regarding it. I explained to him that, this was well within the parameters of my department to handle and move forward. And he actually asked that the city be given an opportunity to work with her or work with them and see if that we can come to a resolution that doesn't necessarily come from the enforcement side. That is when they decided to accept Mr. Lott's assistance, and he did again coordinate with local church and best way dumpster removal. Although that they changed their minds thereafter apparently and ceased all conversation with them. While I was on site the other day posting, it was May 3rd, when I posted the notice and updated the photos for the file to show the most current condition. I did speak with the neighbor. The neighbor did state that pretty much after we leave, they can come out and converse with them, and that she had hoped that I would have more luck than the last guy that was there, i.e. likely Mr. Lau.
So is the process, if they don't act on this document, that you'll take rights to the property or demolish the building on your own and send them a bill, or how are you going to complete this problem?
Right, so moving forward, there would be a number of options. Condemnation would not be one of them that I know of. Of course, I would work through the City of Greenwood Legal Department and be advised on what proper steps. I do know that the city taking action and removing the structure is certainly one of those options. So not the property or the primary residence as a whole, but potentially moving in and demolishing the failing structure, and then of course the owners would be liable for payment of reimbursement from the city, as well as any other penalties imposed. And there would be a number of ways our legal department can recoup those as well.
Thank you.
And then one last question, if we give the motion for this demolition, do they have an opportunity to get all their stuff out? Not that they would act on it because they haven't yet, but is that?
Well, that would be up to you because you're gonna give an order and get a period of time for them to make a repair, and then it would be demoed, and so they would know, well, the period of time they would have to get the stuff out if they don't demo it, or if they want to take it out and repair.
Right, and or, if there's any personal property located in the building, I don't want to assume, but it would be my intent that property be removed prior to the demolition as best it can be. There may be objects of value in there. be of real value or sentimental, and I would not want to affect that. However, if they then don't have proper storage or suitable area for that, you know, it may turn into another issue, whereas you can see there is still debris scattered about the rear yard. So it may be a compound problem, but I think that the right thing to do would be to give them that opportunity.
I went by and viewed the property. Viewed the shed, and as someone with a degree in structural engineering, I looked at that shed and noticed that on the north and south sides, that's where the openings occur. So there's not much shear resistance, and it's leaning to the east. So when it was first built, it didn't have a lot of resistance to leaning east or west. And so in its current dilapidated condition, I really believe at any given time that thing could fall over. It's close enough to the property line. You could take out that black fence or injure someone on the east property. It happens to be standing on their driveway.
I would worry about the children that are around that area.
I worry about those too.
Well, yeah.
So, yeah, I've got a great deal of concern about how long we have before we have an accident.
I agree.
Okay, is there anything else on enforcement action?
Very simply that what we're here to speak about, hopefully, or at least the intent was with the owners, was to have the property raised completely within 30 days of the hearing. Of course, the Plan Commission does have the authority to affirm that, modify that, or deny that. Timeline for this order in full. And that a demolition permit be obtained from my office within 15 days. Of course, that gives the the required departments enough time to review prior to issuance. And then again, within the 30 days from today's date, be raised and removed.
Okay, thank you.
Yes, sir.
So within between that time, that 15 days, that they come up with a way to work with the church and what Mr. Loud kind of worked out for them, that revert back and allow them to do that for that removal in that way.
If the owners of the property are able to convince the city of Greenwood that the matter will be resolved, then I would gladly work with them on both the timeline and the manner in which it is resolved. Absolutely.
Thank you.
Anything else? Normally, the next item that we would do is the owner and any other person who has substantial property interest are offered the opportunity to cross-examine the enforcement authority's witness, meaning Mr. Seal. Seeing none in the audience, is there anybody who is online who wishes to?
They have to be the owner or have a substantial property interest.
Right. Is there anybody wishing to cross-examine the enforcement authorities witness, who is Mr. Seal?
Were they invited to the meeting or notified of the meeting?
That's what the.
What documents
That's
they
what
take?
all the door and mail
Posting
to
on the
it.
property was.
Okay, seeing no activity, it's now the Plan Commission's duty to conclude the hearing, which close the hearing, and either affirm the building commissioner's order or rescind the building commissioner's order or modify the order. What he said was 30 days to have the issue resolved and the structure either properly repaired or removed. They have a
You have to specifically find Whether it is an unsafe building, cite the reasons why, whether you're affirming or you're modifying, whatever it is you are doing with the order of the building commissioner.
Take a swing at this.
I'll give it a shot.
Okay.
I move to find that the detached accessory structure on a residential property commonly known as 304 East Broadway Street, Greenwood, Indiana, is an unsafe building because it is structurally unsound, it is leaning, and it is in danger of collapse. And that the order requiring Vinnie and Evan Thomas Thornton to demolish the unsafe building that was issued by Building Commissioner Kenneth Seal on May 3rd, 2024 be affirmed. That Vinnie and Eva Thornton be ordered to abate said nuisance by demolishing the detached structure within 30 days and to direct the city attorney to prepare findings of fact and order, setting forth the decision to affirm the building commissioner's order. Said findings to specifically incorporate the evidence submitted into the record for adoption at the next regularly scheduled commission meeting.
I would make one suggestion that in addition to demolish it within 30 days, apply for the demo permit within 15 days.
And that the property owner be required to apply for the demolition permit within 15 days.
Second.
We have a motion by Mr. Lexi, second by Mr. King. Is there no. Any further questions, comments? Being none, all those in favor of this motion, please show by raising a hand. All opposed, same sign. Motion carries 9-0. Mr. Seal, we have affirmed your order. Thank you. Next item on the agenda in new business is PC 2022-075, Scottsdale Estates, Section 2, secondary approval of plat. This is an agreement for electrical services. Is there someone who is?
Yes. Yes. Hi, can you hear me?
Yes.
Hello, members of Plan Commission. My name is Adam Mears. I'm with Gradison Land Development. We are the developers of Scottsdale Estates. You may recall last month at the Plan Commission meeting, we presented this same contract for Section 1 of Scottsdale Estates. This is regarding Section 2 of Scottsdale Estates. As you're aware, Indiana Code 36-74709 goes into detail about how subdivision plats are to be accepted. When it comes to infrastructure that's not completed, we are performance bonding all of the incomplete infrastructure and intend to be on the Board of Public Works agenda next week. However, because electric service is out of our control, we can't performance bond something that we don't have control over. So we're here just asking for your approval to accept this agreement pursuant to that statute as evidence that we are committed to getting this electric service done. I will give you an update that I got this morning from JCREMC that for both of our Section 1 and Section 2, they've got 2 small jobs ahead of us. They anticipate being to Scottsdale in the next 4 to 5 weeks. And our intent here is to continue moving with the platting so that when JCREMC is done, we've finished all the administrative things and we're ready to go. So appreciate your approval of the Section 1 acceptance of that agreement and asking you to do the same here for Section 2. And I'd be happy to answer any questions.
Yes, not saying anything negative against Johnson County or EMC or any other utility, but from a developer standpoint, it is very difficult to make a utility move.
Yes, I would agree wholeheartedly.
Same holds true for a city.
It's completely out of our control. We do have a good relationship with JCRMC, and I know they're pumping to get there. We're just trying to keep our ball moving so that the second they're done, we're able to sell some houses.
All right, Mr. Nelson?
Staff really has no concerns as long as the agreement is provided and there's a plan to have these installed at a later date.
Okay, Mr. St. John, did you have any input on it?
Nothing additional. Harrison and Arbor Homes are aware that they will not be able to construct homes without, well, sell homes without electric power in place, so.
Probably wouldn't be a lot of buyers either.
That's true. We're just trying to keep the administrative stuff going on our end so that the second we're hot, we're able to hit the ground running immediately and not have that additional 30-45 days of them trying to set these meetings. So again, appreciate your consideration.
Thank you.
The legal department has reviewed the agreement and it indicates that they will be installed in compliance with the UDO, which has very few regulations on how those are installed, because that's a heavily regulated by statute and other regulations.
Mr. President, I
Yes.
move to determine that petitioner Scottsdale Development LLC written contract with Johnson County REMC is presented provides satisfactory assurance that electric utility service system of Scottsdale Estate Section 2 will be installed and extended in compliance with the subdivision control provisions of the Unified Development Ordinance.
We have a motion by Ms. Stambaugh. Is there a second? Mr. Price? Any questions or comments about the motion? Seeing none, all those in favor, please show by raising a hand. All opposed, same sign. Motion passes 9-0.
Thank you all very much. Have a good night.
Okay, you too. Okay, is there any new business from the floor? Being none, I know one announcement we have is the next meeting is not going to be on May 27th due to the Memorial Day holiday. It'll be on Wednesday, May 29th. Are there any other announcements?
That was the one.
I stole your thunder. We'll take one more motion.
Move to adjourn.
Oops.